thank you all for having me here today. It is a pleasure for me to be visiting this beautiful country and this beautiful city, and it is a real honor and a pleasure for me to be speaking at this important conference. I only wish that I could be speaking at this conference in Spanish, but unfortunately I cannot speak Spanish, so I apologize to you that have to be wearing the headsets. As you heard, I am the chief of the Money Laundering and Asset Forfeiture Unit at the U.S. Attorney's Office in the Southern District of New York. This is a division of the U.S. Department of Justice, and we prosecute all federal crimes that occur in the New York area, and sometimes a little bit broader than that, as you'll see from some of our cases. And my unit handles all the money laundering and asset forfeiture cases in the office. And I'm going to talk to you a little bit about U.S. asset forfeiture law, as well as a little bit about the U.S. money laundering laws. So what is asset forfeiture? What I always say is asset forfeiture is how we take the profit out of crime. It's a legal procedure where the government takes property without compensating the owner because the property was involved in the crime. And the reason for why we do it, there's several different purposes to asset forfeiture. First of all, it's a punishment. I'm going to talk to you in a moment about the different kinds of forfeiture. There's a criminal forfeiture and there's a non-conviction-based forfeiture. But in general, forfeiture is punishment, is part of a sentence for a defendant. It's a punishment for a federal crime that was committed. Then it's important to remove the property that makes the crime possible. If it's money laundering, to move the property that the money is laundered through. If it's narcotics trafficking, to remove the instrumentalities of that. And why? Well, one, to disrupt the criminal organization. The goal of these laws are to disrupt and to dismantle criminal organizations, whether it's organized crime networks, terrorist networks, narcotics trafficking networks. They depend upon the money they make. They depend upon the property they use. The best way to disrupt them, to stop them, is to take away the money, to take away the property they use. Then this will deter illegal activity. At the end of the day, if the U.S. government prosecutes somebody and puts them in jail for the crime, say fraud or drug trafficking, but when they do 10 years in jail, 20 years in jail, they come out of jail and they have millions and millions of dollars, then that's really not much of a deterrence. In fact, I'm sure if all of you think about it, if someone gave you 20 million US dollars, would you do a couple of years in jail? I think many people would say yes for the right amount of money. So it's very important under the US law as part of deterrence to take away those crime proceeds so that criminal organizations don't still have that money. They don't have that profit. And then finally, in cases with victims, it's important to be able to get that money, to get those crime proceeds and return them to victims. That's a very, very important component of U.S. asset forfeiture laws, to take that property away from the criminal and give it back to the person that they stole it from. And we're seeing more and more in terrorism cases, taking the money away from the terrorist organization and giving it back to the victims of terrorism. And then finally, not one of the main purposes, but a nice benefit of it is the money that's collected, the money that's in that forfeiture fund, if foreign governments or state and local governments work with the federal government on a forfeiture case, the U.S. government, then they have the ability to share in the money that's forfeited. So if, for example, the U.S. worked on a forfeiture action that involved drug money and the government of Argentina provided some assistance to the U.S. government in the investigation, the government may be able to share in some of the money that's forfeited, assuming that they're not victims in the case, because money goes back to victims first. So those are some of the reasons for asset forfeiture and some of the benefits for asset forfeiture. Now let me just explain to you a little bit about what can be forfeited. There's two categories of property that can be forfeited. There are proceeds of crime, and there's property that facilitates a crime. And proceeds is under the forfeiture law is very broad. In most cases, it's gross proceeds. So if you have a drug organization, it's going to be the value of the drugs that are moved. If it's a money laundering organization, it's going to be all the money laundered, not the profit that the launderer made. The second category of property is property that facilitates a crime. It's going to be, so in terms of the proceeds, let me just go back to the proceeds. It's property that the wrongdoer would not have had but for the crime. And that example would be cash that was acquired by unlawful activity through drug sales. It's going to be a but-for test. But for the crime, would you have the money? Again, and it's going to be the gross proceeds. The way it's defined under the law is property of any kind obtained directly or indirectly as a result of the offense, or property traceable to that. Oops. And that includes, as I said, traceable property. That's going to be property that is acquired with crime proceeds. So that's going to be the yacht that was bought with the cash made through the drug sales. Or it's going to be a home that was bought, or a car that was bought, or any property that was bought with crime proceeds. So now I'm going to give you some examples of traceable property that was forcible as traceable to crime proceeds. And I have a lot of pictures because there's a lot of crime in New York, or a lot of crime that goes through New York. So you can see there's a lot of big fancy properties that we were able to forfeit. Now this is an estate in New Jersey that belonged to Philip Bennett. He was the CEO of a financial services company, Revco. And what Revco did was that Phil Bennett and other officers of Revco, they actually had a huge debt in the company. They had all these trading losses, and the company was really in the hole. It should have been in bankruptcy, but they would have been out of jobs. They wouldn't have had any money. So what they did is they actually conspired with a bunch of other people to lie about the condition of the company. And first, they engaged in a leverage buyout and got hundreds of $millions from an outside investor. And then when that wasn't enough money, they did an initial public offering, and they sold stock in the company. But of course, it turned out to be worthless. The company was underwater. And when the hole in the company, all the debt was revealed, the stock became worthless. And Mr. Bennett and his co-conspirators were arrested for securities fraud, and ultimately the court entered a forfeiture judgment of $2.4 billion. That was the proceeds of the offense. So we were able to forfeit from Phil Bennett his estate in New Jersey. He also had an apartment on Park Avenue. We were able to forfeit that as well. And then he had lots of what we call toys. He had race cars. He had an airplane. We were able to forfeit all of those as well. And then he had a big art collection. I've discovered a lot of things about people in my job as a prosecutor. And one of them is criminals, if after they buy the cars and the boats and all of that, they love modern art collections. I think that actually having a conference at an art museum is probably the perfect venue, because the really rich love their art. And it seems a lot of the defendants in our cases have bought artwork by Mark Rothko. Here's 3 Mark Rothkos that Phil Bennett had. These were also forfeited. So the property that was forfeited, it was all forfeited and sold, and the money went back to victims. Now, in addition to that, as part of the fraud, there was an Austrian bank, Bauwag Bank, that helped the company Revco commit the fraud. It helped them to hide the losses. And the U.S. government entered into an agreement with Bauwag Bank, and they agreed to forfeit $437.5 million, which was money that was also returned to the victims. Now, the other category of property is facilitating property. And that's property that makes the crime either easier to commit or more difficult to detect or obstruct. And the most obvious examples are a house where drug sales occur, an airplane that transports drugs, a warehouse where drugs are packaged. All of those things, if you take property that was bought legitimately with legal money, clean money, and you use it for the purposes of engaging in narcotics trafficking, or use it for the purposes of laundering money, or for engaging in child pornography, or several other offenses, that property is forfeitable. And regardless of whether or not you bought it with legitimate money in the first place, that property can be forfeitable to the United States. And here's some examples of some of the things that we forfeited. We forfeited a Cessna that was used to transport cocaine. And actually the Marshal Service collects the property for the government. And the US government has forfeited a lot of airplanes. We actually have an airplane hangar where they store some of the planes that have been forfeited. So which crimes is forfeiture available? Now, the hard thing is, if you actually are someone that studied US law, forfeiture is not in one place. You're not going to open up a criminal law book and you're going to see forfeiture and you're going to see all the laws there. There's no one US law that authorizes forfeiture. It's developed piecemeal over time. It's expanded and expanded. So it's found under many different statutes. But the ones that are the most significant ones, the forfeiture laws that we use all the time, are narcotics trafficking, which allows us to forfeit both the proceeds of the offense and any property that facilitates it. For money laundering, the forfeiture law is enormously broad. It's not just proceeds or facilitating property, it's property involved in money laundering. So that can be the proceeds of the offense. It can also be the property that's used, a business that's used to launder money, but it can be a very, very, very broad. In fact, we brought a very significant case this past year against a hedge fund in New York, SAC Capital. And many of the officers at the company, or many of the managing directors, were engaged in insider trading. And we criminally charged the company with insider trading. We also brought a civil money laundering action and forfeiture action against the hedge fund itself on the theory that it was facilitating the insider trading, and we sought to forfeit it. And what limits the forfeiture of a business in that context is, just under US law, it's going to be whether it was grossly disproportionate to the crime. It's going to be what we call an Eighth Amendment analysis. Is the forfeiture unfair because it's so grossly disproportionate? In that SAC Capital case, we ended up settling the case by releasing the fund, and in return, the fund agreed to forfeit $900 million. So it can be, the forfeiture law can be very, very broad, and can be, in and of itself, can be a very significant punishment or penalty. Some of the other bases for forfeiture are terrorism. Very broad laws on terrorism. In fact, under the US laws, any national or international terrorist, the government can forfeit any of their assets. And then there's more than 200 other federal crimes where we can forfeit the proceeds of those crimes. That's going to be any type of fraud, public corruption, child pornography. In all of those cases, the US government can forfeit the proceeds of those crimes. One of the important purposes of forfeiture, as I said before, is to give money back to the victims, victim restitution. And the Department of Justice uses the asset forfeiture laws to freeze, seize, and restrain property so it's available to compensate victims. Let me briefly tell you, here's an example of a forfeiture that we brought that was the proceeds of crime. This is the Castle at Tarrytown. This is actually a hotel that's a little bit north of New York City. It's a Relais and Chateau 5-star luxury hotel. And this hotel was bought by a gentleman by the name of Hans Peter Walter. He was a private banker at UBS, and what he did is he handled all of these Saudi Arabian customers that were never in the United States. They just kept their money in the United States, and he invested it for them. Unbeknownst to them, he bought this hotel. He created a corporation, he made himself the CEO of the corporation, and he started to run the hotel. He put $54 million into this hotel to make it one of the most world-class, beautiful, small hotels. It was a very big wedding location. A lot of people I know got married there. And he put his wife into design to be the interior decorator, and his daughter and son-in-law were the innkeepers. They were running the hotel. His fraud was ultimately discovered. He was arrested, and the government forfeited this hotel. For a period of time, people that worked for me were actually running the hotel, you know, getting involved in planning weddings, and then we ultimately were able to sell the hotel and give the money back to the victims. There's two types of forfeiture. There's criminal forfeiture, that's part of a criminal case. It's based upon a criminal conviction. And there's civil in rem forfeiture, or non-conviction-based forfeiture. Here's another property that we criminally forfeited. This was a house that was owned by Jimmy Ida. He was an organized crime member. This house, this beautiful estate, was bought with racketeering proceeds. So we were able to forfeit that property as part of his criminal case. Now, just generally, criminal forfeiture, it's a part of a criminal case. It's a part of a sentence. There has to be a conviction. If there's no conviction, no criminal forfeiture, and we only forfeit the defendant's interest in property. Now, I'm going to tell you about, this is one of my favorite cases I've ever worked on. This gentleman right here, he doesn't look very good right here, but this is Mark Dreyer. He actually, at one point in time, was one of the most prominent attorneys in New York City. He had gone to Harvard and to Yale. He ran a 270-lawyer law firm in New York. And he made a lot of money from the law firm, but the problem with when you live in New York City, oftentimes there's people that are wealthier than you and live a bigger, better life. And he was a greedy fellow, and he wanted more. So he started off small. What he started doing was stealing from his clients. He wanted to buy something, he took a little bit of money out of their account with the idea he'd pay it back eventually. That ultimately, once he took that first step, it wasn't enough for him. So he came up with this crazy idea. He created this, this fake promissory note program. He had represented a real estate company, and what he did was he pretended to represent them, and he claimed that because of the financial crisis, they needed to get these sort of secret promissory notes. And he went to the biggest hedge funds in Manhattan with the most sophisticated bankers, and he offered them these promissory notes. And he claimed that he, the lawyer, was the broker for it. And shockingly, all of them agreed, and they paid him hundreds of millions of dollars for these promissory notes. But there were no notes, and it was really just a Ponzi scheme where he was paying back one to the other and paying himself. So in order to keep this fraud going, he hired people to impersonate the people at the real estate company. And he had a whole fake set of phones to answer the phone as if they were the real estate company, and hired someone to answer those phones. But at one point, one of the hedge funds wanted to meet with the chief financial officer of the realty company. So he was in a dilemma. What would he do? He was a very brazen guy. He had represented the real estate company, so he knew a lot of the people there. He knew the receptionist. So he went in one day with the guy he hired to play the chief financial officer, and he went in and said he had a meeting with someone and was going to be using this conference room, and went into an open conference room. He put the chief financial officer at the head of the table, and then he went downstairs and met the hedge fund who were coming into the lobby, and brought them upstairs into this conference room, which is all glass, and they had the meeting with the fake CFO, the actor, pretending to be the chief financial officer. And in fact, at one point, the real chief financial officer walked by. It's a glass conference room. He saw them sitting at the table, talking, thought nothing of it, just walked on by. Anyway, Mark Dreyer continued doing this for a while. He bought, I'm going to show you some of the things that he bought with that money, but eventually he couldn't keep it up. I mean, there was no end game here for him. He had no exit strategy, and he just had to keep paying back people with interest. So after he sort of ran through everybody that would want to invest in the real estate promissory notes, he wanted to go back to the same people for other things. So he had an idea that he would work with a Canadian pension fund to sell their notes. But there was no Canadian pension fund. So what he did is he found one, and he flew up to Canada to meet with them, claiming he wanted to pitch them to do legal work. He got up there, and you have to be, this will teach you to be very careful with your business cards. I'm sure everybody here is exchanging cards. Well, look what happens with the card. He meets the guy from the head of the pension fund, meets Mark Dreyer. They shake hands, exchange cards, have a meeting, and then Mark Dreyer says, okay, that meeting is over, and he says, do you mind if I use one of your conference rooms? My plane isn't leaving for a while. The head of the pension fund says, no problem, make yourself comfortable, etc. Mark Dreyer then goes downstairs to the lobby where he meets another set of hedge fund people that are coming in from New York. He meets them in the lobby. He hands them the card of the guy that he just met. The head of the Canadian Pension Fund introduces himself as the head of the Canadian Pension Fund and brings them up to the conference room for the meeting. Unfortunately, he wasn't so smooth in how he did that, and someone started to suspect something. They asked the receptionist who that is. She said who he really was, and he was arrested in Canada for a misdemeanor impersonation. But at the same time, the U.S. government had information about what was going on. So when he arrived, this is when he arrived at the airport. He was then promptly arrested by officers from my office. So now let's see why he did this. Let's look at some of the things he bought with his crime proceeds. So first of all, he bought a $10 million cooperative apartment in the Bloomberg building. And I will tell you, it was a very beautiful apartment, incredible views of the city. Then he bought, and this is, you take one thing away from what I am telling you, do not buy a yacht. It loses money. This was an $8 million yacht. We forfeited it, and the US government lost a lot of money. Yachts need a lot of money to maintain. But he bought himself a beautiful yacht, Lady Seascape. Then in New York, the sort of vacation area that people want to go to is the Hamptons. And to have a house on the Hamptons is like the most desirable thing. So Mark Dreyer bought himself a house in the Hamptons. What you can't see is, this is the front yard. The backyard is right on the Atlantic Ocean. Gorgeous, beautiful, private beach. That wasn't enough for him. See, this is sort of a relatively simple house for a man of such means. So he bought the house next door, a bigger, better house next door, also on the ocean. Now, Mark Dreyer was divorced with 2 children. It's not quite clear why he needed 2 giant mansions on the ocean, but when it's not your money, you can be very generous. Then it was the art collection. You can see some of these prices, $6.6 million. $1.5 million. That's a, I'd have to show you my favorite one in a second. These are Andy Warhol's $2 million. This is a screen. This was for $600,000. It was a screen, a plasma screen with a picture of Salma Hayek. $4.2 million, $6.5 million, $5.6 million. So he bought over $35 million worth of art, and he literally would take the money, he would steal the money from the hedge fund, and he would just wire transfer it to the art gallery. Anyway, he was ultimately convicted. He's serving about 20 years in jail, and we got a forfeiture order for over $700 million, and any of the money we're forfeiting is going back to the victims of his fraud. Now, you've probably all heard of Bernie Madoff. My office also handled the Madoff case. Now, that was we thought, it's actually the Mark Dreyer case was going on right around the same time as Madoff, and it was a huge story in all the big press in New York, and the New York Post, it was front page story about Mark Dreyer. Lucky for Mark Dreyer, that like 2 days later, Bernie Madoff was arrested. So, and obviously that was probably one of the biggest stories ever. So there's Bernie and Ruth Madoff, and we got a $170 billion forfeiture judgment against Bernie Madoff. Now remember, it's gross proceeds, so the fact that he's paying one victim back with another's money isn't gonna reduce the amount of his forfeiture because it's gross proceeds. So we forfeited his apartment on Park Avenue. We forfeited, he also had a house in the Hamptons. We forfeited his house in the Hamptons. And then we forfeited like all of his stuff, jewelry, his slippers. I'm not embarrassed to say we even forfeited his underwear, though I'm embarrassed to say that people actually bought his underwear, his art, though he didn't have such nice art. His suits, his shoes. Anyway, the way that forfeited property typically is sold is in most cases, U.S. Marshal Service sells it. They actually have a website. If you go look up Google U.S. Marshal Service auction, you can see a website where you can like bid on things and buy like an old tractor trailer that was used for drug trafficking. Or because there was such public interest in the Bernie Madoff auction, we actually had a big auction. Look at all the press there, where there was like a live auction where they sold his stuff. The underwear was sold in a lot. You didn't just get one pair of underwear. You got a couple things together. I think socks were included. But you know, it obviously generated tremendous amounts of money. And to date, this is what we've forfeited. We've actually forfeited a bit more because some of the other defendants were convicted, but we forfeited over $4 billion. And one of the things that is worth noting is, if you look there is the J.P. Morgan Chase resolution for $1.7 billion. That was actually a case that my office just resolved this year. In January of this year, my office filed a deferred criminal charges against J.P. Morgan Chase, and obviously a huge U.S. financial institution, because of their connection to the Madoff Ponzi scheme. Under U.S. law, banks are required to have anti-money laundering programs and to report suspicious activity. But and it's a violation of the Bank Secrecy Act, a U.S. anti-money laundering law, not to file suspicious activity reports. But unfortunately, J.P. Morgan Chase failed to file suspicious activity reports on the conduct of the Bernie Madoff Securities Fund, and even though they had reason to be suspicious of that activity. So my office reached an agreement with J.P. Morgan Chase where the bank was criminally charged, but the charges would be deferred for 2 years if the bank did 3 things. One, admit the conduct, which they did, which was the failure to have an effective anti-money laundering program and a failure to file suspicious activity reports, pay $1.7 billion to go to Madoff victims, and to reform its AML, its anti-money laundering policies, which got a resolution where the family received $19 million for the painting. So even if it's a crime that occurred in, during the Holocaust, there still may be a basis to forfeit it and return the property to its true owner. Quickly about a civil in rem action, it's brought against the property because it's proceeds of crime or property that facilitates a crime. There's no need for a criminal conviction. And but it has to have a connection to the criminal activity. And under U.S. law, in criminal cases, the standard of proof is beyond a reasonable doubt. However, in forfeiture, be it criminal forfeiture or civil forfeiture, the standard of proof for property is less than it is for liberty. And that standard is preponderance of the evidence, more likely than not. And what happens is we file a complaint against the property. It has these funny names, U.S. versus Portrait of Wiley, U.S. versus 1 Ford Taurus. And people that claim an interest in the property file a claim, and then it's litigated like any other civil action in a U.S. court. Here are some examples of things that we forfeited. We forfeited a pizza parlor that was purchased with drug proceeds. People always seem to be, drug dealers always want to get out of the business, so, or have some legitimate income. So we were able to forfeit a pizza parlor. We were able to forfeit cars that were used as collateral for a drug deal. This is a case actually that we were just worked on. This is Silk Road. I don't know if any of you have ever heard of it. It is a website. It literally is a marketplace for buying illegal drugs. This is the page. If you went online, you couldn't just go online. You have to go onto the Tor network, which is on the dark web. It's a secret network that you have to have this special software that you can go on. And the purpose of it is you can't trace who goes on it. It masks the IP users. But if you went on Silk Road, you can buy like any kind of drug you want. And they were buying and selling all different kinds of drugs on there, and fake IDs, hacking, materials for hacking, all different types of property that facilitated crimes or things related to drug trafficking. And the person who administered Silk Road, or its creator, was someone that the government, who's called Dread Pirate Roberts. If anybody has seen the movie Princess Bride, he named himself after the character in Princess Bride. But his name was Ross Peter Ulrich, and he is going to be going on trial in November, but the government has alleged that he was the administrator of the Silk Road website, and ultimately through some incredible investigative work, the FBI was able to identify him, and they actually were able to arrest him at the San Francisco Public Library. But what we did was we brought a forfeiture action against the Silk Road website because we wanted people to stop being able to use it right away. So what we did is we did a domain name seizure. We were able to seize this website. So if you went on to buy, if you were someone that wanted to go on and buy drugs that day, you went on and this is what you got. The website was, this hidden site has been seized by the FBI in conjunction with a whole bunch of other law enforcement agencies, and there was the legal authority for the seizure. And in addition to this, the other interesting thing about Silk Road is that you couldn't buy things in regular money. You couldn't use credit cards. The way you bought things were with bitcoins, this anonymous digital currency that only exists on the internet. I've had people, I can't really explain exactly what it is, but whatever it is, it's something that just exists in the internet. It doesn't look like that. There's nothing to it. However, we were able to seize over $120 million worth of bitcoins. And the United States Marshal Service is in the process of auctioning off these bitcoins, and they're selling them and turning them into cash. Another area that I don't want to run over, so I'm just going to run through this very quickly. In addition to not wanting crime proceeds to, we use the forfeiture laws to take away crime proceeds for all those purposes, we also don't want the U.S. to be a haven for stolen or looted art or cultural property. So the forfeiture laws actually allow the United States to seize and forfeit stolen or looted cultural property, and there's various different U.S. customs laws that allows us to seize these things if things are smuggled or imported by false statements, or if it's subject to a UNESCO convention. And I'll just show you a couple of things that we've recently forfeited. We forfeited this platter that was looted from Italy. It was worth several $1 million. We forfeited this wall panel that was stolen from this tomb in China. There's a lot of stolen manuscripts. A lot of times people go into archives and they just cut them out and they show up on the black market. We were able to forfeit one from Mexico, but from other places as well. Now, people have always been asking me when I'm here, have you done any Argentinian cases? Here is a case that I worked on with the U.S. Attorney's Office in Arizona, where we actually forfeited these dinosaur eggs. Now, I'm sure you probably know that Argentina has very significant cultural property laws that protects its archaeological and paleontological materials. And in most cases, the government owns that property, and you can't just dig up something in Patagonia, find a dinosaur egg, and take it and sell it. However, people do that all the time. And so what the customs, people sell this stuff not just from Argentina, but people do it from all different countries and the U.S. People are always, even though there's laws prohibiting it, people will dig up things, and I'll show you a couple other cases where this has happened. But here at a big gem and mineral show in Arizona, Homeland Security's investigations discovered that they were selling a whole bunch of someone was selling a whole bunch of Argentinian fossils and dinosaur eggs. Here are some of them. And we were able to forfeit these and return these to Argentina. It was obviously a lot of stuff to be returned, but there were a lot of things there. Some other cases is we recently brought a forfeiture action against this 10th century statue that was looted from this temple in Cambodia. It was part of a whole looting network that was going on during the Vietnam War. And all of these, this used to be full of statues. All these statues were cut down and transported over the Cambodian-Thai border and sold to the Western art market. And here's more of the temple. And it was the twin of one at another U.S. museum, the Norton Simon, and there were 2 other ones at the Metropolitan Museum of Art. And I'm very happy to say that ultimately all the museums that had them agreed to return them to Cambodia. Oh, and you say, how did we know that these were the same? The feet were still there. You could actually match the statues. The feet were still in the ground at the temple. Anyway, there was a very nice ceremony. They were returned. We had a nice ceremony in New York. They were returned to Cambodia. Now, Argentina is not the other country with dinosaurs. Mongolia actually has a lot of dinosaurs. And this dinosaur was offered for sale at an auction house in the United States. And we were able to forfeit it and return it to Mongolia. And here were some more of them that we were able to forfeit and return. For some reason, Americans love dinosaurs. They love to buy, really wealthy Americans love to buy dinosaurs and put them in their homes. Someone bought this one for their home, someone bought the other one for them. You have to have a really, really big house to fit this guy in your living room. But people do that. That one sold for over $1 million. And we ultimately had a nice ceremony where we were able to return, that's the head of the Tyrannosaurus bataar.
Sharon, sorry to interrupt. You have 10 more minutes.
Okay. Now I'm going to quickly talk about money laundering. Now, generally, the most simple way to describe money laundering under U.S. law is hiding, spending, transferring, reusing crime proceeds, or helping someone else to do it, either as part of your job or just helping them. And it cuts across all types of activity. Any crime, anything that's a specified unlawful activity that can proceed, that can be forfeited, it can also be laundered. And here are a list of all of the various different money laundering laws, but most significantly, it's money laundering is laundering money, engaging in financial transactions with various different intents, a specific intent, and they're concealing the money, promoting the specified unlawful activity, or avoiding paying taxes. And the other significant one, or particularly significant for all of you, is and a specified unlawful activity is any one of these federal offenses, but it also, the ones that I talked about before that are a basis for forfeiture, but it also includes things like foreign corruption proceeds. If it's proceeds of a foreign crime and it's laundered into, it can be laundered into the United States. So we have cases where it's money that's obtained from a foreign fraud and it's brought into the United States. That transfer of the money would be international money laundering. And for international money laundering, it's going to be the international transfer of the money either into or out of the United States. But one of the key components is typically it has to be crime proceeds that are moved, not for international money laundering. It can be movement of money into the United States for the purpose of committing the crime. So it can be legitimate money that's brought into the U.S. for the purpose of buying drugs. Legitimate money brought into the United States for the purposes of engaging in a fraud. That clean money, that legitimate money, is bringing that into the United States for the purpose of committing a crime is a basis for money laundering. Now I'm going to very quickly talk to you about one of the cases, a big case that we brought in the office. This is an action against Lebanese Canadian Bank. This was a Lebanese bank, and essentially what we did was, working with the DEA Special Operations Division and the Department of Treasury, we learned about this massive trade-based money laundering scheme. And trade-based money laundering is essentially taking crime proceeds and exchanging it for a commercial good so that good can sort of move through the process. And we discovered this very, very large scheme, but it wasn't something that was necessarily being done by one person in the United States that we would prosecute. Now, let me explain to you a little bit about it. What would happen is money would be transferred from Lebanese Canadian Bank into the United States, and that money would be used to buy low-value used cars. What happened was that Lebanese Canadian Bank, people with accounts at Lebanese Canadian Bank would transfer money into the United States and into accounts in the United States. And these young Lebanese men would come with debit cards from the U.S. bank into the U.S., and they would go to auto auctions all over the United States, go to these car dealers. Typically, there were also people that they knew from their town, like a friend of a friend, and they would buy these very, very low-value cars worth less than $1,000 US, And then what would happen is they would ship these cars. There was a shipping company involved. They would ship these cars to Kakatau, Benin, which is in West Africa. Now, if you go on Google Earth and you look at Kakatau, Benin, there are these giant car lots there. It turns out that this is a big marketplace for West Africa. People from all over West Africa come to Benin and they buy cars, and they buy it in the local currency. But at the car lot, they have these money remitters or exchangers, and what they do is they exchange the local currency for US dollars. So where do the US dollars come from? They actually come from the West Africa drug trade. We had all this evidence that money, that a lot of the drug trade is done in dollars, and that money from this drug trade here would end up at these car lots. That money would be commingled with the money, would be exchanged for the money, and then that money would be moved across the border. That cocaine money, for the most part, would be moved down the border of West Africa, across the Togo-Ghana border. There it goes, down the Togo-Ghana. You can see my high-tech graphics here so you can understand. Crosses all languages. It goes from Togo to Ghana. And then the interesting part about that is Hezbollah, which is a terrorist organization in the United States, a designated terrorist organization. Hezbollah is part of this process. Hezbollah made money doing this. The people that moved the drugs down the border, for the most part, they were people that worked with Hezbollah. And as part of this process, they would pay money to Hezbollah to be able to move that money through. They controlled the couriers that moved the money through. Then the money would move from Ghana, and it would have to go through Europe because there's no direct flights from Ghana to Lebanon. And we had a couple of seizures at airports in France, in Germany, and then the money would go to Beirut, Lebanon. And again, at the airport, at the airport, Hezbollah operatives would come and escort the couriers off the plane, and the money would be deposited in Lebanese Canadian Bank. The US dollars would be deposited in Lebanese Canadian Bank, and it would come back to the United States, and then it would be used, it would go out again to fund the cars. During our time period, which was a little bit less than 2 years, $468 million moved through the US in this process, and that's the stuff that we detected. So we brought in action, we worked with Treasury. Treasury designated Lebanese Canadian Bank as a primary money laundering concern, and Lebanese Canadian Bank was essentially barred from the US market. So it was a case where we were able to expose the connection to Hezbollah and also to expose this money laundering ring, which as far as we know is not operating anymore. The last thing I want to talk about is this case, which shows that really anything can be laundered, or anything can be turned into money laundering. And this is an $8 million painting by Jean-Michel Basquiat. I do this presentation for a lot of children, a lot of different groups. And whenever I do it for children, they always laugh when I say that's worth $8 million US dollars. But anyway, this painting and was owned by this gentleman, Edmar Cid Ferreira. He was the head of a bank in Brazil, Banco Santos. And in that case, he embezzled over $200 million from the bank. And what he did with that money is, it was a big story in Brazil at the time. He was sentenced to 21 years in jail. And what he did with the money is, with the money that he embezzled in part, is he bought this phenomenal modern art collection. So Brazil has similar money laundering laws and forfeiture laws to the US. They went to seize it, and the paintings were gone. The whole collection was gone. And what we discovered is that, and here's just a representation from Hannibal, the stuff left Brazil, it went to the Netherlands, then it went to the UK, and then it came to the United States. And it came into the United States, it was concealed, it was identified as, you have to identify things when they come into the United States on customs forms. It was identified as a painting by an unknown artist worth less than $100. And I'm sure it's not going to come as a surprise to you that the people at the border that examined this did not recognize that it was an $8 million painting and seize it. So ultimately, there were numerous other paintings that came through the US that way. This Liechtenstein, this Torres Garcia, This Polyakov, it ultimately went to Switzerland, but we were able to forfeit it anyway. This statue, and we ultimately were able to bring an action against them, and we ultimately were able to forfeit it and return them to Brazil. So, and we still have more to do, but that's a good example of how anything can be converted into something that can be laundered and something that can be moved. It can be fraud money, it can be embezzle money, it can be drug money, it can be terrorism money. If I have one more minute, I just want to tell you about one other case that we did. It was just because it was such a significant case. In July, we brought an action against BNP Paribas, a French bank. And they pled guilty to a conspiracy to process transactions through the U.S. financial system for Sudanese, Iranian, and Cuban customers who were subject to U.S. economic sanctions. And as I'm sure many of you know, the United States has various different laws that embargoes that prevent certain individuals, countries, or entities from doing business in the U.S. or doing business through the U.S. financial system. And here what happened was for more than 8 years, BNP Paribas knowingly and willfully moved $8.8 billion through the U.S. financial system on behalf of these sanctioned entities, including more than $4 billion that was moved on behalf of terrorist organizations, narcotics traffickers, or money launderers, or what has been identified as specially designated nationals. And people that are prohibited because they're either a terrorist, a narcotics trafficker, or a money launderer, they're barred from the U.S. financial system at all. So ultimately, BNP Paribas pled guilty to a conspiracy to violate U.S. sanctions laws, and they agreed to forfeit more than $8.8 billion for, which was the amount of money that they moved through the U.S. financial system. So the reason why I want to talk to you about this case is that the U.S. takes its economic embargoes and sanctions very, very seriously, and it will prosecute a financial institution who willfully violates these embargoes and moves funds through the U.S. financial system. And just like we'll prosecute individuals that will, or entities that will launder money through the U.S., it's something that the U.S. government takes very seriously, and only by sort of vigorous and aggressive enforcement can we try and accomplish the deterrence and all of the things that I discussed at the beginning. Thank you.
Thank you very much, Sharon. It was a very interesting presentation.